One of the most common mistakes we come across at HM Capital Management is the improper titling of our clients' homes. Whether it is a new, existing, or secondary home, proper titling of a home is important and requires more thought than most people would think.
Home titling can be a confusing topic because generally, people receive advice to title all assets in the name of their trust. By titling your home in trust name, you are ignoring creditor protection considerations, as this protection only applies if your house is properly titled.
Although rarely needed, having creditor protection can provide significant peace of mind for you and your family. For example, let's say you seriously injured someone in a car accident or were the subject of a malpractice suit brought against you professionally. These types of examples could result in you being sued and a judgment of potentially millions of dollars. A home titled in the name of your trust could be used to settle the judgment, forcing you and your loved ones out of your home.
For reasons such as these, we recommend titling a home in joint name. This way, if you or your spouse had a judgment enforced, the house is not subject to creditors because it's titled jointly.
Another common concern is what happens if you or your spouse were to pass away. If the home is titled in joint name, it would be subject to probate taxes, which could be 4 to 5% of the home's value, not to mention the time, headache, and cost of going through the legal process.
To alleviate the probate issue, we recommend adding a beneficiary deed to the home. This way, if you or your spouse were to pass away, the home automatically changes ownership to whoever is named on the beneficiary deed, which is usually the survivor's trust. An estate planning attorney can draft a beneficiary deed for a few $100s. This is well worth the cost, as probate could be tens of thousands of dollars.
Unfortunately, the benefits provided by a beneficiary deed are not available in every state because only half the states allow for these filings. Even if you live in a state that does not allow for a beneficiary deed, we believe the benefit of creditor protection by titling a home in joint name outweighs any probate costs.
If you are single or if your spouse passes away, we recommend titling a home in the name of your trust, as joint creditor protection no longer applies.
As you can see, something as simple as titling a home has many factors to consider. If you have any questions or need additional information, please feel free to reach out to us by visiting our website or giving us a call.